please settle down. And your phones, please try to put them on silent or you can switch them off.
All rise. The court is now in session. Today's proceedings went well, although it was just an adjournment. The lead counsel of Peter Obi and the Labour Party moved a motion for adjournment because all the parties haven't filed their responses. INEC already accepted that they did not file all their responses to the Labour Party's petition. The reason that they gave was because they weren't served early, which led to their not having enough time to file their replies. So all parties, including the APC, Tinubu, and Shetima's legal teams, all accepted that the court moves for an adjournment so that when they come back on the 17th of May 2023, that all parties must have filed all their replies and the case will move faster. It looks like a setback, but in reality, it will make things easier and faster for the court. When they look at all the replies and responses from all the parties, they will know where they stand. No need for going back and forth. They will know, yes, this one is opposing this, they are accepting this one. It will make things faster, although a lot of people are now apprehensive because the May 29th date is already approaching, and many people are thinking that this case should be disposed of before the swearing in. Yes, in Kenya, they disposed their election dispute in a few days, just about a few weeks. In Nigeria, we can do better. We can even do it faster than the Kenyans. We are supposed to set an example in Africa, but it's a pity that we have found ourselves in this situation. There's no law in Nigeria that makes it mandatory that all cases must be disposed before swearing in. Right now, such a law does not exist. But looking at the current situation in the country, this is the most contested election in Nigeria's history. The judges and the judiciary at large should understand that the citizens of this country are looking up to them to save democracy. Time is of essence. They should do all they can to answer the questions that the petitioners have posed. The question of 25% in Abuja, the disqualification, the double nomination of Shetima. In fact, the 25% should be the fastest they can decide. They do not need responses from anyone. It's just an interpretation of the law because it is written right in our constitution. They just need to interpret what "and" means. And we all know the meaning of "and." There's no two ways about it. It has the same meaning, whether in law or in anywhere. The Constitution is written in plain English. So this decision can be done in one day. And if it is done, it nullifies the declaration made by INEC, which will lead to the return of the return certificate that was issued to Tinubu. So the 17th is the next adjournment for Peter Obi and the Labour Party's petition to continue at the Presidential Election Petition Tribunal.
The train don't move.
Before Peter Obi's case was heard in court, the Action People's Congress withdrew their case against Tinubu, APC, and INEC. After the withdrawal, the head of the APC legal team made a statement urging other parties to toe the same path and withdraw their own cases against the candidate of their party. This is not what is expected from someone who won an election. If truly their party won the presidential election, they should be proud that the Presidential Election Petitions Tribunal have given them the opportunity to prove that they really won. To set the record straight that they actually won, that they didn't rig, as all the opposition parties are saying. It's just like arguing with someone and it doesn't seem like the person is believing what you're saying. And all of a sudden, you get the opportunity to prove the matter in court. You will jump up in enthusiasm and say, yes, this is my opportunity to prove to people that I actually won this election. And I will do it and prove it beyond reasonable doubt that, yes, we actually won the election, that it wasn't rigged. But instead, look at what we're seeing, coercing people to withdraw their cases. Why not allow them to test their case in court? Let them test the law. Let them set precedents like the Supreme Court set yesterday when it ruled on the appeal from the petition of Oyetola versus Adeleke. The Supreme Court maintained that in order to prove overvoting in an election, that the Beavers report must be produced, the voters register must be produced, and the EC8A forms, the information contained in them, must be produced also in order to determine if there was overvoting. Actually, why Oyetola lost was because the Supreme Court said that his allegation that there was overvoting was based on hearsay, that he didn't prove with reliable data that there was actually an overvoting in the 774 polling units where he claimed that there was overvoting. This judgment is very important because all the judgments that the Supreme Court have passed will become judicial precedents that other judges will rely on to pass future judgments. Although going through the Peter Obi's petition, he's not solely relying on overvoting. They have evidence that their votes were suppressed. They have polling unit results to prove their case. But they need to also get the CTCs from INEC, which they have not supplied them. They have not granted them access to all of them. Even though a court ruled that they should do that, they've not complied. Also, the Supreme Court said something about the back-end server. It said that it might not be accurate because the beavers might fail to transmit records for several reasons, including poor internet connection, loss of battery power, and failure of INEC officials to properly press the submit button, among others. While this is a very logical take from the judges and from the technical point of view, we shouldn't rely on the mistake of INEC. When Nigeria spent billions of naira to perfect the system, remember that the software running on the beavers was developed by the INEC IT head, the former INEC IT head, because he was transferred a few weeks to the election. His team developed it and made it available to the supplier, the Chinese supplier that supplied the beavers. They installed the software on the beavers machines before supplying it to INEC. And INEC tested the system. They conducted many tests, mock voting, to prove the system that it is efficient, that it works well. If they had found a problem with it, whether it's uploading of the results or any of the logical reasons that the court found that will make the data not reliable, they should have stopped at that point in order to correct the problems, so that it will be at least perfect, near perfect for the conduct of the election. So this take is actually what everyone should be concerned about, because they won't just be presenting the polling unit results. They will need the INEC beavers report in order to prove, yes, this is actually the number of voters here. You can see it is reflected on the polling unit result. Although these are technicalities, if they have to approach this matter based on the reality on ground, they should know that merely comparing two results that are identical nullifies whatever result that INEC will produce, because they can't issue two results on the same day. If the results of two parties matches and that of police also matches with that of the two parties, then it will mean that the one INEC will submit should be the fake one, although it shouldn't be so. But we all know what happened during the election. Anyway, this is not in any way saying that the judgment of the Supreme Court on Oyetola versus Adeleke is a perversion of justice or that justice was not delivered. We all know that Adeleke won the election as declared by INEC, but this is purely on how the judgment relates to the ongoing Presidential Election Petition Tribunal. Nigerians expect the judges to look at judicial precedents while they deliver judgment, especially on the 25% in Abuja, the disqualification of Tinubu, and others. This right here, the judgment of the Supreme Court on Oyetola versus Adeleke, is also a judicial precedent that they will rely on while delivering judgment. So it all depends. They should not look at technicalities or, like they say, big grammar. They should look at why the intention of INEC by preventing upload of election results right there at the polling unit, as the law says. If they are able to look at the intention, they will know that that intention can never produce anything meaningful, anything that the world or people can trust. So Nigerians are watching, the world is also watching. We all hope that judgment will be delivered. Thanks for watching.